Section 1GG of the Constitution of Paja excludes, and this let me just, because there's confusion here. Yeah, this is for English 3.
Is it not a provision that relates to the legislative side of Parliament?
No, it's the one about the JSC, the GG, yeah. But I'll just demonstrate now that it's not as simple and as the other side want us to believe.
1GG of what?
1GG of Paja. The first one I said, Justice Muda, was 1DD, Section 1DD. That's the one about Fetcho and Likota and so on. This one is 1GG, which is a different exclusion. But I'll just show, as I was saying, yeah, it requires a reading of English scholars. So it says that the following is not. 64, oh, is it quoted there? Oh, thank you, Justice. Yes. 64. Yes. It's quoted there. Thank you so much. Yes. It's a,
argument is that the process of the decision to designate does not fall.
is excluded by in Paja.
This decision, does it not have an external legal effect? Because once it's done, it affects an independent constitutional body that is not part of the that is not part of the
Understand.
National Assembly, and that is not within the workings of the National Day-to-Day workings of the National Assembly.
Okay.
Whatever decision was made during that process affects an external body, which is not within the National Assembly itself. And the workings of that external constitutional body are directly affected by that decision.
Okay.
Can it not?
Okay. Justice, let me do it like this, just to save time. The expression direct legal effect doesn't mean that. It means the rights of others. But forget that. Assume I'm wrong about that. I'm saying my primary submission, so that we don't get waylaid by the direct legal effect that was mentioned in Likota as an add-on. Yeah, it's just an add-on. The point is that the exclusion in Section 1DD is the Fetcho exclusion. And that exclusion is enough, so you don't need, you can scratch out this one about direct legal effect. So the exclusion in 1DD is sufficient to make Paja inapplicable. And then the next one, which I'm going to deal with, is 1GG. Right? And it says, a decision, sorry, because, just to answer your question again. Remember in Likota they were saying, because the reason it has no direct effect is because the matter concerns the in-house workings of Parliament. Yes, but the answer I gave is I stand by that or fall by it. But on 1GG, then it says the following. It excludes a decision relating to any aspect, and please listen carefully, any aspect relating to, there's a whole case law about what that means, relating to, in connection with, and all that. Yeah. Any aspect, we know that's wide enough, regarding the nomination, selection, or appointment of a judicial officer or any other person by the Judicial Service Commission in terms of any law. Right? So, this thing that that has been brought to you, this decision, nobody can, with their straight face, debate that it does not relate to an aspect regarding to the nomination, selection, or appointment of judicial officers by the JSC. Because that's what they are saying. They're saying we must prevent him from appointing judges and or selecting. And I'll show you why, where the English thing is.
Am I missing something? That
Yes.
the one DG of Faja not related to the inner workings of the JSC?
No, that's exact. No, it doesn't. If the JSC, by the way, does not nominate, neither does it appoint judicial officers. Let's just get that one out of the way. Selection, maybe, that's a debatable one because they recommend. Yeah. So that's where the English is, the English 3 lesson. That word by the Judicial Service Commission is not qualifying the expression a decision. So it's qualified by relating to any aspect regarding the nomination, selection, appointment. And the first point I want to make is the Masetla point, which says that when you talk about appointment, as one minister once said, the president has a right to appoint and disappoint. So when you talk about appoint, you're also talking about the non-appointment or removal in the same breath. There's a lot of case law that those rights are two sides of the same coin. So a decision relating to any aspect regarding the nomination, selection, appointment, as I say, removal, and all the things that are related to those of a judicial officer by the Judicial Service Commission in terms of any law. And I'll leave it at that because I don't want to waste more time on this. But the exclusion is either on any one of those 3 grounds. The strongest is the one about the legislative function, and then external legal effects subject to Justice Mbele's concerns. And then the third one is the 1GG. Any one of them is enough, so that's why I don't want to waste time on this. But we all know the question would be, well, so what then, Mr. Hlophe? Because if Pacha doesn't apply, then legality applies. But let me explain why legality itself doesn't apply, or at least is unfounded on this. I've already said that the main thrust of the so-called legality attack is the rationality. And you can't have the rationality test divorced from the other issues I raised about Chapter 2. I'll come to that. But the most serious reason why, assuming now we're left with legality, the most serious reason why that is an impediment is the separation of powers doctrine. Because that doctrine says that you cannot have a judiocracy or rule by judges. It's a rule by the people. And it says judges cannot usurp the exclusive functions of the National Assembly to designate or remove members of the JSC. There are many serious reasons why a court should not do that. One is that, as I've said, this is an expression of the will of the people. I explained that in the morning. And so the court cannot second guess the people. And we have given an article, I'm sure the judges have seen it, I'm not going to go into it now. There's an article at 47-661 called Popular Constitutionalism, Departmentalism, and Judicial Supremacy. So that article exposes this, what is happening in this country at an alarming rate. The notion that the judiciary is supreme. people think that when you say the constitution is supreme, you mean that the judiciary is supreme. That's not true. The judiciary is itself, as I say, notionally an organ of state. We know about, I mean, it's not a normal organ of state, but it's an institution, let's call it like that, an institution of the state. And section 2 of the, remember I talked about the structure from section 2, but I want to go to section 8, 8.1 of the Constitution. Makes this point. The judges will know about this. I'm sorry, I'm just doing it for. It says, the Bill of Rights applies to all law and binds the legislature, the executive, the judiciary, and all organs of state. So all organs of state and the judiciary and the legislature are bound by the Bill of Rights. So if the Bill of Rights says you must do this, that's why in Mokanyane the court removed the death sentence, because itself is bound by the Constitution, by the Bill of Rights, Section 11, as Justice Mudau pointed out earlier. So the judicial supremacy is something that we must root out because it is not sanctioned by the Constitution. And with that goes the notion that you cannot, there's a person called Kramer, Larry Kramer, who's quoted in that article. He puts it more beautifully than I can ever say. He says, he argues for a world in which, you'll find that at 47-661, they say Kramer argues for a world in which the courts, quote, see themselves in relation to the public, somewhat as lower court judges now see themselves in relation to the court, to the constitutional court, their Supreme Court. Responsible, the courts are responsible for interpreting the Constitution according to their best judgment, but with an awareness that there is a higher authority out there with the power to overturn their decisions. An actual authority too, not some abstract people who spoke once 200 years ago and then disappeared. That's a very, very serious statement. That's why I was saying the people are allowed to change their mind. We can't think the people just spoke in 1996 and wrote a constitution and then they disappeared. They're here, and they've placed Dr. Hlophe in the JSC. And the court must respect that because that is the higher authority over the courts, the people. And they say that decision of the people must be respected in the same way that this court would respect a decision of the SCA or a decision of the Constitutional Court. It's more binding, to be exact, more binding than that. So that's the separation of powers rationale. No, but that's exactly what I've just read. They are, yeah. No, well, it looks like we're not. Let me read it again. Yeah, it says, responsible for interpreting the Constitution, what we just said, according to their best judgment, but with an awareness that there is a higher authority out there with the power to overturn their decision, an actual authority, not some abstract people who spoke once 200 years ago. So the starting point of this is that courts are responsible for interpreting the Constitution. But there are limits, right? There's deference, there are constitutional limits, let's put it that way. Yes. Now, the issue here is that let's come to Justice Passon's point about rationality. Because everyone, when we talk about this, they bring rationality as a red flag. Say, well, it must be rational, which is true. But rationality itself has to be placed in the context of the Constitution, as I said earlier, in that it must be, it really means a consistency with the Constitution. But here's the thing, coming closer to home. The way rationality has been abused in this court is beyond any description. I'll tell you what has been done to try and pull the wool over the eyes of the court. Rationality, as Justice Basson was saying, it only means this. It means that there must be a rational connection between the means employed and the purpose of the empowering provision. That you will find in the DA case, I think it's 47-150. Yes. Paragraph 32. Oh, no, sorry, 32 of the case at 47-158. So, yeah, it quotes the usual cases, Albert and pharmaceutical and so on.
Can you read back that?
Yes, 47-158, thank you. So it talks about, I'll paraphrase, it talks about, it's a long passage, the relationship between means employed to achieve a particular purpose on the one hand, and the purpose or end itself. Now here, let me explain why this is important. You've been told here that you must link the means to something called the purpose of the JSC. But that's wrong. There's no such thing. That's mixing water and oil. What you must look at is the purpose of Section 1 of the empowering provision, which is Section 178(1)H. Of course, within as I said earlier, within the context of the whole Constitution. What does Section 178(1)H, what is it about really? What is the purpose of that empowering provision? Not all these fancy things that have been said here. I'll show you the purpose. It says the National 6 persons designated by the National Assembly from among its members, at least 3 of whom must, underline must, be members of opposition parties represented in the Assembly. So it's peremptory. It says the National Assembly must make sure that it has 6 people, 3 of whom must be members of the opposition. So what is the purpose of that? It's what Mr. Masuku, in fancier language, calls it an anti-majoritarian clause. That's the only purpose of that thing. It is to prevent the tyranny of the majority in Parliament. Because if we did not have Section 178(1)H, no member of the opposition would ever be a member of the JSC. This, according to F.W. de Klerk at least, was inserted by the white minority in the discussions at CODESA as a minority protection measure, because knowing that the numbers are what they are, none of them would ever have been sitting in the JSC if there was no section 178(1)H. Now it's,
Check and balances in used to.
that's what they used to call it, yeah, which meant that just stop the black people. So the so-called checks and balances in that context was to say, look, this overwhelming majority will just swallow us. So let's have certain measures to literally make sure that there's minority protection. That's the purpose, the simple purpose of 178(1)H. It is to ensure that opposition parties are represented. Now, you have to, when you're doing a rationality analysis, you have to say what happened. And my learned friend, Ms. Hassim, has told you chapter and verse. The speaker has told you in her affidavit. Oh, that's all you have to go to say what happened. That's the so-called the means. So the means, nobody disputes what the means are. Nobody has disputed that. This is what happened. There was a vote, there was a debate, this one won, this one lost, and what have you. We know from Mr. Hassim's address and from the Speaker's Parliament. Now, all you need to do a rationality test, it's not rocket science, is to link that to the purpose of Section 171H. Did what happened there achieve the purpose of minority protection? Yes or no? The answer is yes. Otherwise, Dr. Hlophe, Mr. Malema, and I think Mr. Trollip would not be in the JSC today. So that's the purpose of that provision. So you can't say, let's do the means and then find some other ends in the air. No, the means must be connected to the ends, the purpose of the empowering provision. And in this case, the rationality test is passed with flying colors because that has been achieved. Now, the word must there is used advisedly. It's not a recommendation. Must, 50% of those 6 must be members of the opposition. So don't listen to all the fancy footwork. Just ask a simple question. Is the means that is employed and explained by the speaker connected to the purpose? Then comes the biggest red herring in this case, the so-called Manga test. There is no such thing as a Manga test. And to the extent that there is, it doesn't make any difference. I'll explain just now. We're told that, okay, Mr. Masuku, we agree, which I'm sure everyone agrees, that there are criteria for being a member of the JSC for the NA. And by the way, those criteria are many. It's just that they are subsumed in 2. There are many, there are about 8 or so if you really think about it. But let's take them in their big aggregated fashion. The first criterion is that you must be a member of the National Assembly. The second one is that you must be a member of the opposition in the context that we are talking about here. And then a third one is that you must be nominated by your party. I'll concentrate on the first 2. If you don't meet those 3, then you can't be in the position that Dr. Hlophe is in. So the 2 which are important are, for the purposes, the opposition and the membership. Now, under the membership, there are other, shall we call them, sub-criteria. So you must also not be of unsound mind, all the things Mr. Masuku spoke about, which you find in section 47. You must be not of unsound mind, unrehabilitated, insolvent. If you were convicted, then it must be after 5 years, and so on and so on. And section 48, you must take the oath. Very important. Because section 48 of the Constitution says that until such time that you've taken the oath, you are not, you can't do anything. So section 48 says, before members of the National Assembly begin to perform their functions in the Assembly, they must swear or affirm faithfulness to the Republic and obedience to the Constitution in accordance with Schedule 2. So before you do that, you can't do anything. You can't go to the JSC, you can't do anything. Now, that's an important criterion for various reasons which are relevant to this case. So there's a host of criteria. You must be a citizen, you must be eligible to vote, all those things. You'll get that from section 47 and section 19. You must be an adult. You'll get that from section 19(3)(b). There's endless criteria. So that basket of criteria is what is meant by the selection criteria. Okay? This notion that there are other, whether you call it character or whatever, selection or whatever, but extra to this basket is absolutely, has no foundation in law, logic, in the Constitution. It just sits in the heads of the applicants. There is nothing else that is required by the Constitution or the Bill of Rights. The Bill of Rights says, justices, everybody has the full protection of Section 19 to hold office. Even the child of a slave, the child of the domestic worker, like me, everybody has the right to hold of public office in this country. And that includes Dr. Hlophe. And it includes everyone who's eligible to vote. In other words, it includes a serial rapist who has spent 5 years after their sentence. Uncomfortable as that is, but that is what the Constitution permits. You can be the pedophile that Mr. Badlander was talking about. But once you've served your sentence, in terms of Section 47(1), and you've got 5 years, you are eligible to be the president of our country and appoint judges. Actually appoint, not just be one of 23, or recommend or whatever. Actually appoint the Chief Justice, appoint the DCJ, appoint all the JPs, appoint all the judges.
I just wanted to correct the criterion that you said earlier on, that you should be a member of the National Assembly, member of the opposition, that the third one should be nominated by the parties. I think that the nominated by the parties is not catered for in that section. But it happens that there was a gentleman's agreement, should I say that, in the chief whips forum, where the political parties say, to facilitate these, would then say, we then agree that the parties would appoint or nominate their candidates who would be designated by the National Assembly.
No, I'll explain what what the nomination. You're right to the extent that you say, Justice, it doesn't appear in the thing, but it's part of the rules of Parliament. You see, that's the other red herring here. It's made as if this thing has got some special thing. There's nothing special about this. Parliament works like this. You just have to go to this record here. You'll see that there were people who were put into the Pan-African Parliament. There were people who were put in the Magistrates Commission. There were people who were put in this and that and the other. All of them followed the same procedure. Yeah, the party, when you say a party is not a thing. It's a juristic person. So the political party is not something you can touch. So the political party, when you say the political party puts so-and-so, all it means is that it will follow its own internal processes. They'll do whatever they do. The Parliament is not interested in that. If they say you are doing it according to age or gender or whatever, that's their business. But the point is that the person representing that party is then put up. So that's what I mean by nomination. It's a simple process of just forwarding a name. I don't know what to call it. So, and it's not about gentleman's agreement. The gentleman's agreement is about this, Justice, or if you want to call it, or what we call the convention, or the unwritten rule.
Forwarding a name in this context is not what we understand to be nomination.
Yes,
Am I
no.
correct?
Yeah, 100%. That's why I'm simplifying it. Yeah, it's forwarding a name, putting up a name, suggesting someone, whatever. So the gentleman's agreement, quote unquote, and ladies, I hope, agreement, is this: that once we are forwarded a name as the advocates party here, we then forward the name of Mr. Mwela. Then the other parties will take that name as our nominee. That's all. And even that is logic. I mean, really, you don't need to be a politician. Once we have, it could be a football club. Once Orlando Pirates has chosen who's going to be their captain, that person is taken as the captain. It's just everyday logic. So that's the nomination part. But I'll come to that. That's why I was saying I'm concentrating on the two. And that, by the way, to come back to the issues of this case, Parliament has no option. They have to rubber stamp that. Let me put it clear. In the sense that they have no say in the nomination processes.
So they will disagree with the National Assembly's position in that regard?
No, we're coming to designation. I'm talking about nomination.
Oh, I beg your pardon.
Yes. Yeah. I'm talking about nomination, Justice Mudam. That's what this confusion is about, because everyone conflates the nomination and the designation. These are two separate juridical acts. And once you make that mistake, you're going to go, in this case, you'll go on some off-ramp to nowhere. The nomination is, if you want to use, I hate that word, but I'll use it. It's a prerogative of the political party.
The political decision.
Yes, and it's a political decision. Both are political decisions, but we'll come to that.
But the Parliament designates in this situation.
Yes, as I said, we'll come to designation just now. Yeah. Just now. Let's deal with nomination. So nomination is a prerogative of the party. We all agreed about that. Then we come to designation, which is what this case is all about. The designation is a decision of the National Assembly, and the National Assembly only. Right?
Everyone seems to agree on that.
Well, no. Well, everyone except the applicants. Yeah. So, if we accept that designation is a function of the National Assembly, and we accept what I said, that the criteria are set out in various parts of the Constitution, principally Section 19, which goes with Section 10. Section 19, it was said in August, in the August case, that the right to vote is a badge of dignity, particularly in the South African context. So human dignity and the freedom to vote are two sides of the same coin. Now, what then happens here is that those criteria, which are, you will find the criteria in Section 10, 9, 19, 47, and 48. All those criteria is what the National Assembly must then process in the designation. And the National Assembly has said, it said this to FUL and all the others who wrote when those guys were mobilized, all these others. KSAC, Judges Matter, Helen Suzman, the usual suspects. Okay, no. Okay. Yes, okay, let me, then I'll do it the long way. There is, everyone knows who lives in South Africa, that there's a group of NGOs that do what is done here. And that's why in this particular case, we have the DA, FUL, Corruption Watch, and AfriForum who took this particular cause. And then we know from that letter that you had KSAC, Judges Matter, Helen Suzman Foundation, Defend Our Democracy, and Ahmed Kathrada Foundation. So it's about 9 or 10 organizations. If anybody really seriously believes that this was just a coincidence, there was no mobilization, these people just all woke up on the 2nd of July, and well, then...
We don't know that, we don't have that.
Yes, no. I'm just saying that, yeah, therefore we must then assume that they all woke up on the 2nd of July and all raised the same issues, all raised the same grounds of review and so on. That's fine. Let's assume that's what happened. So I'm saying the point I was making really is that I've lost my point now.
While we are still trying to get your thought process straight, looking at Section
178, yes, valid.
Would you disagree if one would say the responsibility to designate in terms of that section lies with the
NA, yes. No, I would agree 100%.
And the National Assembly, there's nothing that stops the National Assembly. But let's say bar the Chief Whips Forum agreement. That bars the National Assembly to say, you are bringing us candidate X. We as the National Assembly believe that candidate X will not be able to represent us. And we can have candidate X, candidate Y from your party to represent us in this. Because it is the National Assembly that has to designate 3 people from the opposition party. And then they would say, it's this opposition party, A, B, and C. And you have the candidate B from that opposition party. And will say, candidate B does not fit
the requirements.
The requirement. And as the National Assembly, we believe that we can have candidate A representing the interests of the National Assembly better than candidate B in this specific forum.
Yes.
Literally giving the interpretation of what it is.
Yes. No, there is something that stops that. It's called the Constitution. You can't do that. What is the National Assembly? What is it? It's not those buildings there. It's the 400 members.
It is group of people under one roof.
Yes, 400 of them. One of them is Mr. Hlophe, Dr. Hlophe. All right? Okay. So the 400 people cannot just shout. They make their decisions by voting. All right? That's the only method that is there for them to. So that's exactly what happened, what you are saying, Justice Mbele. There was a candidate. Some of the people in the National Assembly objected, which was the first time it was happening in 30 years. Because of that, the matter was put to the vote. Because that's the only way that the National Assembly can decide. So the National Assembly could have done what you're saying. Say, we reject this person. How would they do that? By voting against. Yes. It's as simple as that.
That's exactly where I was going. There could be another process of rejecting that individual.
No.
Which would be by voting against this individual.
Yes, but that's the point I'm making. That's exactly what happened here. So why are we here then? Because the National Assembly did exactly that. It said, okay, for the first time, there's an objection. Normally, the names just go. But because of that, my learned friend, Ms. Hassim SC, explained this very simply, and so did the speaker. Because there was an objection, then they said, and it's not true that the DA called for a division of the House. That is not true. Because there was that objection, the speaker then asked the National Assembly, what do you want to do?
That's exactly where I was heading with Mr. Paul.
Yes.
That if they had the process of voting resulted in another outcome,
Yeah,
that would have been the decision of the National Assembly.
absolutely.
So what I'm trying to say is, the National Assembly is not barred from
Rejecting. From rejecting. Rejecting the name.
Yes.
No, it's
And
not.
It's not bad because had they voted and the result
Yeah,
were in the
yes.
the opposite,
yeah.
it would still have been the decision of the National Assembly.
Yes, but that's the point. The National Assembly cannot be barred from voting. That's what it does. That's the only thing it does for 5 years at least. When it chooses the president, it votes. When it chooses the speaker, it votes. When it chooses the portfolio committee on this, it votes. That's the only way. This thing called the National Assembly is not.
When it decides to impeach that same president, it votes.
Exactly. It's a decision. The decision that you are asked to review here is a decision of the National Assembly, which lies solely in its purview, not yours. That's the point I'm making. So, can I just finish this thought? Sorry, Justice Passon. Yeah. So the point I'm making, Justice Mbele, is that what the National Assembly did was exactly what it is enjoined to do by the Constitution. And there is no reason why you can prescribe to it and say, no, you must think this way, or vote this way, or vote that way, or whatever. The only thing that you are allowed to do, as Justice Passon pointed out earlier, would be to say whether in that process the means were connected to the purpose. Sorry, Justice Passon.
My point is simple. If Parliament, the National Assembly, can
It voted the other way. Yeah.
or accept, that implies that the criteria in 178(1)H are not cast in stone.
No. It's got nothing.
Yes, no, I'm glad you agree, because they are not cast in stone. So that can't be the premise.
No. They are cast in stone. There's nothing that can ever be cast in stone than something in the constitution of a country. That's bigger than a stone. It's cast in the. It's bolder, yeah, bolder, yes. It's cast in the Table Mountain. No, Justice Passon. The criteria, if you see Mr. Masuku's point, I keep on coming back to it. If anyone, whether it's the DA or anyone or the court, feels like there's something missing in those criteria, the thing is very simple. it must go back to Parliament to legislate. Whether it's in the Constitution, remember Parliament can amend the Constitution by 75%, or it can pass a section in the JSC Act, or it can pass rules. Not the court. It's got absolutely nothing to do with the court. This. So to come to the Manga fallacy, I'm sorry to use Justice Madanga's name in that same sentence. Such an erudite person.
I wonder what they would be flash.
Before you get there,
yes.
before you get to that point, now that we've agreed that the decision is the decision of the National Assembly, they can put it to a vote whether to decide otherwise. Is that decision
No, it can be. Remember, that's why we're saying that decision is within the exclusive purview of Parliament. That decision can only be reviewable if it was in your purview, subject to what Justice Basson has said, which is the following, that it's also said in the case of August. Parliament cannot second guess. I'm sorry. The judiciary cannot second guess Parliament. Whether those people were drinking something or whatever, that's too bad. So you are not allowed to second guess Parliament's choice. And that's why this case is a fallacy. Because this case is based on the following lie. I can't put it lower than that. That all the National Assembly did was just close its hands and then say, well, MK has put Dr. Hlophe, so he must go to the JSC. No. That would be rubber stamping. But the National Assembly knew that it has a discretion, the one you and I have been debating now, Justice Mbele. So it said, no, we have a discretion. Even MK was saying, no, you must just take our name, whatever. And the others, on the other side, FUL and the KSAC, they said, no, you can't have this vote. The National Assembly said, no, you're both wrong.
I don't think the issue is whether or not they can vote or not. The issue is what they should take into account when vote.
No, yes, that's what I was coming to. You can. Okay, let me say this again. The issues you can take account are those 10, 8 or 9 issues that I said. Are you an adult? Are you a citizen of South Africa? Are you not of unsound mind? Are you a member of the opposition? And so on and so on. So those are the criteria. The question, Justices, and this is where the Madlanga fallacy comes in, is whether on top of the criteria that we all in this room agree, there is an added criterion called character, suitability, whatever. That's the only question, really. And the answer is no, there isn't. And there isn't because Madlanga J's dictum, obiter dictum at that, is being butchered in front of your eyes.
On what basis are you contending that it was obiter dictum?
It was obiter dictum. That case was about, I almost said it wasn't it. That case was about the record, whether the JSC can release a record. That was the ratio of that case. The obiter, everything else that was said which doesn't deal with that is not a ratio decidendi of that case. But I don't want to get into the Latin. So it was a remark.
But it was said in the process of the trace,
Yeah.
the point that because that decision was taken by people with certain qualities and conditions.
Yes.
They would have been,
Yeah, no, everything in a judgment, obiter and ratio, they're all said in patres. Yeah, but it doesn't change it from being an obiter dictum. just because it's said in a judgment. Actually, obiter dictum can only be found in a judgment. Okay, so it says, he says, since our courts, I'm now at paragraph 37, you find 47-286. Since our courts play a crucial role in constitutional democracy, without that the JSC's function in recommending appointments, to senior judiciaries of singular importance. And this is the part that is being abused. Bearing in mind the importance of this function, I do not think it unreasonable. It's not laying some law of 12 tables. I do not think it unreasonable to expect, so he doesn't think it's unreasonable to expect that those that bear the responsibility of nominating, underline that, nominating, designating, or electing individuals, right? In other words, the political parties, the ones who nominate in this context are the political parties. The ones who designate, the NA, we've all agreed. Those who elect the president when he elects his or the law teachers or whatever. Individuals for membership of the JSC will take their responsibility seriously and identify people who are suitably qualified for the position. Now, all that means really is that those people who are given those three tasks, nominating, that's the political parties and the others, it's not unreasonable to expect them to follow the criteria properly. In other words, let's assume the criteria said we only want women. Just a wild example. So those who are tasked with that task, it's not unreasonable to expect that they're not going to nominate men, because the criterion is there, it's clear, it says women. That doesn't mean there's an extra criterion except the gender one in that example. It simply means those who are bringing that person will, because the criteria was written that we only want women or we only want men or whatever it is, then they'll follow that criteria. So to elevate, I'm sorry.
That's 7 minutes to your time. You are left 10 minutes.
10. Okay, thank you, thank you. Let me, if you just allow me to just debunk this one. Okay, and then he says, so that expectation, which is quite normal, that you will follow the criteria that have been set out in the Constitution, is now being elevated to some new criterion that we don't know. We don't know what are the parameters of this new criterion. What is its limit? What is its, what does it say? Nothing. It's just something that we must fathom from the air. Then he says, which makes it clear, this is the part they don't quote. Of course, we cannot be blind to some bad appointments to a variety of senior positions that we have witnessed in litigation that has come before this court. So in other words, even if the criteria result in bad appointments, so to speak, that's tough luck. We have to live with it. He says, but that is not the reason, that is not reason enough. In other words, the fact that there might be a bad appointment is not reason enough to make an assumption that the JSC may well be saddled with bad appointments. Yeah? As for those whom the Constitution has identified for membership by virtue of their office, such as Dr. Hlophe, we cannot second guess the framers of the Constitution in selecting the relevant offices. That's the end of this particular case. We, there means the court, the Constitutional Court, cannot second guess the framers of the Constitution in selecting those relevant offices, which are from 1 to K or whatever it is, okay? By virtue of their office, in other words, by virtue of membership of the National Assembly in this case, or by virtue of being a member of the opposition. By virtue of their office, we cannot second guess the Constitution, Yeah. if anything, and barring individual shortcomings, such as shortcomings that might be identified by the DA and in Judge Hlophe, which from time to time do manifest themselves even in the highest and most respected offices. These offices are eminently qualified for membership of the JSC. Full stop. So, Justice Madlanga says a simple thing, and then it's being twisted here and made something that it is not. He says, we can't second guess the Constitution. We can't, if there are better appointments, well, tough luck, because those offices that have been identified in 171H are eminently qualified to do this job. In which world does that paragraph bring a new criterion of some unknown dimensions? It's a figmentation that is being fed here to take advantage of an obiter dictum that addresses something else, actually that affirms our stance, that of course, and here's the thing, Justices, the word nomination in that passage is very instructive. Because what Justice Madlanga is saying is that even the political parties, because they are the ones who are nominating, or the law officers or whatever it is, they themselves, it's not unreasonable to expect, for example, in this case, that they'll find somebody who has judicial experience. It's not unreasonable. If they have 3 or 4 people, and then it's not unreasonable for them to find the most suitable of them. But that doesn't mean that that person must now no longer be a member of the National Assembly. They must find someone suitable somewhere in their head office in Joburg or wherever. No, that they are still bound by the criteria set out in 178(1)H. The person must be a member, and they must be a member of the opposition. That's all. So let's not abuse Justice Madlanga by... Yes, one of my juniors has given me this, yes. If the National Assembly had then designated a person who's not a member of the opposition, let's say, and had less than 50% of members of the opposition, then the court can say, no. Yeah, this is now irrational because the means you have employed is not connected to the purpose, because the law tells you that it's 50% is the minimum. But now, there's nothing wrong. The case must just be dismissed with the greatest respect. Now, just to round off, if you just allow me this point. You remember I invited everyone to try and imagine the law that they want. Well, surprise, surprise, the Constitution has helped us. Section 89(2) of the Constitution is the law that they want you to amend the Constitution right here, sitting there, the 3 of you. Amend it by putting 89(2) or 178(2) or whatever it is. Here it says, and that also addresses Mr. Trengo's point about the incapacity. That's another red herring. 89(2) takes care of that. You can be impeached without what you call a no-fault impeachment, so to speak. So 89(2) says, anyone who has been removed from the office of the president in terms of subsection 1A or B, in other words, exclude C, which is the incapacity. But if you've been impeached for 1A or B, misconduct or incompetence, may not receive any benefits of that office and may not serve in any public office. They want you to amend the Constitution and include this clause for judges when the framers of the Constitution deliberately did not. Why did the framers of the Constitution deliberately omit a clause like 89.2? Because obviously they wanted a person who has been found guilty of misconduct as a judge not to forfeit their right to serve any public office. It's as simple as that. If the framers of the Constitution wanted that, they would have said it. And they didn't say it deliberately. Judges cannot change that. The last point is this. You cannot juxtapose section 165 of the Constitution with the rights in the Bill of Rights. You can't do that. Section 165 is in chapter 8 of the Constitution. It's not even in chapter 3 or 4 or 5. Chapter 8. It is not a rights conferring section. It is an obligation that is general. It's not even specific to the National Assembly, for all organs of state. Now, if you weigh something like that against dignity, equality, and political freedom, it's a no contest. The scale will be something like this. Because that obligation, important as it is, cannot be used to limit rights. Section 7 of the Constitution is very clear, Justices. It says the state, and that includes the legislature and yourselves, must respect, protect, and promote and fulfill the rights in the Bill of Rights. Must. You now have a legal duty and obligation to do that, to protect the rights in the Bill of Rights, the rights of Dr. Hlophe. Okay, can I just round off this point, Justice. And then it says at 7.3, the rights in the Bill of Rights are subject to the limitations contained or referred to in Section 36 or elsewhere in the bill. What does that mean in simple English? That the right to political freedom, the right to hold office, the right to dignity can only be limited in terms of Section 36 or another right in the bill. And we all know, I'll keep on coming back to Mr. Masuku's point, that if you are allowed to limit those rights, but you must do so by a law of general application, not a Sobukwe clause type of, a law of general application that is discernible, that is reasonable, that is capable of being tested for constitutionality, such as the JSC Act. That's the only way you can do that. You can't restrict, limit, infringe rights in the Bill of Rights by, I don't know, judicial decree of some sort. You can only do so in this way. And I therefore implore you, Justices, firstly, to ignore the noise about the remarks that were made in Part A. I'm not talking about cost. The remarks that were made in Part A, let's assume they were all wrong. Those remarks were made and they are now serving before the Constitutional Court. There's an appeal against the Part A judgment. The most simple laws of our country say that you can't decide something that's before another court because it's lis pendens or it's res judicata or whatever it is. And in any event, if it's before the Constitutional Court, the same issue is, in other words, you could have a decision that goes this way and the Constitutional Court goes that way. That's just not allowed, to put it simplistically. And therefore, that whole thing about the remarks and whether the apology is accepted or not accepted, all that is a matter that is now serving before a higher court. And as far as we are concerned, we have put sufficient reasons in the affidavits to show that this application is nothing but an abuse of the court process and simply, driven by hatred and trying at many points and on time to even, as I said,
You said it,
pull.
but now you are saying it on my time.
What have I
I'm
said?
saying what you are telling us now, you said it earlier. And
No.
now-
Yeah, okay, well, we'll refer to the earlier one. Then, which one? Of what? All right. My learned junior says I won't even go there. Refer you to paragraph 85 of the New Nation case. But while I'm there, I'll also refer you to paragraph 99 and 100 of that case, where Madlanga J makes it clear that Section 157, a right in chapter, whatever chapter it is. New Nation. Oh, it's 85 is the one I got from Leonard Jr. And then the one that I'm giving is 99 and 100 of the same case. Madlanga J said in that case that the same Madlanga J said that you can't Section 157, which is in some chapter, cannot defeat Section 19, which is in the Bill of Rights. And Madlanga J in Amabungane, by the way, said that designation means nothing except the fact that you choose a particular person and inform that person. So the designation cannot be elevated. That one is in our heads. So I won't even give you the reference. He explains what designation is. Designation is simply what the National Assembly did. There's nothing to review, there's nothing to set aside, which is even worse, and the applications must all be dismissed with costs on a punitive scales. I'm indebted to the court for the time. Thank you very much. Appreciate it. Thank you. That's a court business. Thanks. Oh yeah. Afternoon. That's